From Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
And that's right. We are here with FLA Law live on the radio. And we are in the WTAN studios tonight for your live legal call-in talk show. And we do have a special guest this evening who I will introduce you to in just a moment. But as the intro said, this is FLA Law live on the radio, and it is hosted by the law firm of Perenich, Caulfield, Avril Noyes. And as far as you know, we are the oldest injury law firm in the Tampa Bay area. And we are doing this FLA Law live on the radio, although many, many years ago, it used to be a live call-in cable talk show. But we have brought it back, and now we are on the radio, and we have special guests and other personal injury attorneys from our firm who come every Tuesday at 5 p.m. So tonight we have a great special guest. I believe she's on the line. I'll get to her in just a moment. But before we do that, I want everyone to know how they can tune in. I know people are leaving work or they're working late and they want to be able to listen in. So, of course, if you're in your car, you should be listening on the radio. But if not, and you want to stream, we are streaming live on Facebook right now on our law firm page, and that is Perenich, Caulfield, Avril Noyes Injury Lawyers. So if you search Facebook, put the name Perenich, Perenich in the chat box or in the search box, you should be able to find our Facebook live stream, which is streaming live right now, and you'll be able to hear me and my guests on the air tonight. If you don't have a Facebook account, you can do the same thing on YouTube. Just type in Perenich, Caulfield, Avril Noyes Injury Lawyers, and you will see the FLA Law radio show on our YouTube page as well. And so if you need to call in tonight, the number is 441-3000. Again, that's area code 727-441-3000. Now, as I mentioned earlier, we are personal injury attorneys. So if you've been a faithful listener of the show, then you know that's usually the topics that we're talking about. But every now and then we have a special guest come in and lawyers of different practice areas who can give their insight and expertise in the areas of law that they practice in. And so I think it's going to be a great show. And I have a special guest who's also a friend of mine who I asked, and she graciously agreed to join us on the show tonight. So Tamara Felton Howard, are you there?
Yes, I am.
How are you?
I'm doing well, thank you. And yourself?
Thank you. I'm doing well. And I don't want to put all your business out there, but I believe congratulations are in order. Am I
right? Newly married.
I recently saw that. Congratulations. That's a beautiful thing.
Thank you so much.
And so I always tell people usually when I start how I ended up bringing the guests that I have, because usually it's friends or colleagues that I've met along the years. And I first met Tamara many years ago when she was the president of the Fred G. Menace Bar Association, which is near and dear to both of us. It's the Minority Bar Association in Pinellas County. And I was kind of just getting my feet wet and joining voluntary bar associations. And so that's how I first met Tamara. But then we saw each other here more recently because my son and her grandson actually played on the same t-ball team. And so I snagged her up. I said, oh, we have a radio show. Would you like to come on? And she was gracious enough and she said yes. So that's how we have her here tonight. And before we jump into kind of the discussion of what you do and the kind of matters that you handle, I thought it would be good to at least introduce our listeners to you and who you are and what you've done over the years as an attorney. And then, of course, tell us a little bit about your firm and what kind of cases you handle.
Okay, sure. Well, I'm Tamara Felton Howard. I've been practicing in Pinellas County for 26 years. I graduated from Stetson College of Law here locally, and I also have a Juris Doctorate and an MBA from Stetson. And then about 2016, 2014, I went back to school and I got a LLM in real property development law from the University of Miami. So I've mainly been practicing for the past 9 years in the area of probate, and that's really been my specialty. But my prior legal experience, I started my career off as an assistant state attorney with the office of Bernie McCabe here in Pinellas County, and I worked there for about 3 years, and then went into private practice with now Senator Darrell Rousseau, but at the time he was not senator and not in politics. But I practiced with him for about 4 years, and then went out on my own, and I've been a solo practitioner ever since.
Okay. Now, what then made you kind of focus in on probate? I think you've been doing that for the past 9 years or so.
Yes.
And what is it about probate that you enjoy?
Well, probate is interesting. Was an area that I did really well in school, but it was like, it kind of thought of it as maybe not the most exciting area of the law. So I started off like the state attorney's office doing criminal defense, et cetera. But as I matured in my career and just decided that I just enjoyed doing it. Like I would do cases every now and then, and just decided to focus my attention pretty much solely on probate. And it's been a great decision. I actually wish I had started practicing
done it sooner,
probate a long time ago. Yeah.
And I think this region and just the state that we live in, it's important. A lot of people come here for their retirement and the latter years after they finish their career. And then this is a beautiful place to retire and kind of wind down in life. And so I think it's very much needed in this particular community, I would say.
Absolutely.
Although the landscape is shifting a little bit. I saw something recently that said Florida is one of the states, destination states for wealthy younger people actually are now coming to the States. So
well, that's good. We need young people.
Yeah,
too.
The young blood is coming in. They're no longer going to New York and LA. Apparently, Florida is now the destination. But with that being said, then I feel like it's good for our listeners because, to be quite honest, most people may not even know what probate means, or probate, estates, wills, trusts, guardianships. They might kind of all mesh it together and not quite really understand what they are and what the differences are. And so I think it's probably good to at least start off with that and explain what exactly is probate and how some of the other things like wills and such fall into that umbrella.
Absolutely. Do you mind if I give a disclaimer?
Yes, absolutely.
Okay. So obviously I am a probate attorney, but I'm here providing advice as just a service to the general public. Any information given does not constitute an attorney-client relationship. And while the information is about legal issues, it's not intended as legal advice. If you have specific legal advice, then please retain counsel.
Yes. And then, of course, at the end, we will definitely allow you a chance to provide your contact information so that if anybody does wish to speak to you at the end of the show, they'll have the best way to contact you and get in touch with you about their personal matters.
Okay. Sounds good. So in answer to your question, so I'll start with the importance of estate planning. So estate planning is necessary for several reasons. Number one, to carry out your final wishes, to transfer your assets. You may want to name, a guardian, trustee, a personal representative, specifically someone to act in that manner once you pass away. And so it gives you the opportunity to name that person. It often limits disagreements between family members and reduces family stress. Obviously, you don't want to leave behind, a lot for your family members to have to do and create even more grief and stress. And also, the best part for me is preserving generational wealth. So, probate itself, is basically just the legal process of settling someone's estate who has passed away and distributing their assets to their heirs and beneficiaries.
Okay. So then you made a good point, and I feel like we can have a little bit of a conversation about that, because it sounds like, and that's actually the first thing that comes to my mind when I'm thinking of probate and estate, is kind of trying to limit the discord or confusion or any type of, misunderstanding when it comes to after I've passed away, what is going to happen and what if my family, my heirs or those that will take as a part of my estate at the end, how do we limit that? And so one thing comes to mind is how much can you actually limit, and what are you able to really do beyond the grave? Is it so much? Can it be so much that I can say, oh, well, this person gets this when they turn this age? And I feel like there's so many different limitations with that, right?
Right, there are, and there's so many different scenarios. I mean, the best thing, obviously, is to, speak to an attorney about your individual situation, but you can certainly limit some of the stress by, having a will, for example, by, and giving it to people so that they know that you have a will,
right?
And keeping it, updated, making sure that, if you, for example, if you have a life change, a new baby, a new marriage,
keeping it updated,
that you update those documents. So all of that is necessary, but I found that, having it laid out and having, the documents in place really does help usually to relieve the stress. I mean, sometimes you have unavoidable situations where families fighting, they contest the will, etc. But for the most part, it helps.
Yeah. And so in situations where, I guess you have to figure it out as you come along, but in situations where there's a will, but maybe it wasn't, you didn't notify people of where it is or how to find it or what lawyer drafted it. What would you recommend is the best way to approach that every time you're updating your will? Should you be sending it to a family member or notifying people of who your lawyer is? How did that typically work so that you can avoid some of that confusion?
Yeah, I definitely would have a place where you keep your important documents. That's usually the best place, maybe a fireproof, cabinet or something to keep the document in.
Right.
That's usually the best way because you do have to you're supposed to file the original will. So within 10 days of the person passing away, whoever is the custodian of the will is supposed to file the will. As an attorney, I don't hold on to original documents because who knows where I may be at that point.
That makes sense. Yeah.
Right. So I give my clients the original and just tell them to hold on. I do recommend that they give copies to, you don't want to give, every 10 people copies, but if you give maybe 2 or 3 so that they know, yes, in fact she did have a will, or at least they know where to find it, then that avoids some confusion. You don't want to run the risk also of having multiple wills out there. And,
that's what I was going to say. So and it may not be as straightforward, but in my mind, for a person who's never practiced probate in a state and really don't have a whole lot of memory of it from law school, it just seems to me logically that the more recent will would be automatically the one that would govern, right?
That's true. Very. Yeah,
all right.
That's true.
So I could imagine you got one from the 80s, one from, the 90s, and then you got one from 2023. It's like, well, it sounds like the 2023 will would probably be the one that would apply.
That's absolutely correct.
Okay. All right. And so then what kinds of things, we're getting a little bit into the weeds, but what kinds of things can you actually put in a will? Could you get as specific as bank account numbers and things like that, or?
So I don't suggest any bank account numbers because it does become public record, and you don't want your bank account numbers floating around everywhere. But usually, in your will, you want to put general things like, okay, who gets your personal property, and I normally don't, who gets your bank accounts. You might indicate where the accounts are, just so that they'll know where to go. But if you change, accounts, then you got to change your will. If you change banks, you got to change your will. So I definitely wouldn't put any personal information. But some people are under the misconception that wills, when you have a will, you don't have to probate.
You anticipated my next question. Right. So it doesn't allow you just to completely avoid that process.
Absolutely not. Yeah, that's a common misconception. But it's basically instructions. You're just giving instructions as to what would happen, and then you have to go through the next step of actually probating.
Okay, so then if that's the case, and I'm playing a little bit of a devil's advocate here. So if a will is simply just instructions, then what prevents a person from just taking out a notepad and writing down kind of the things that they want or the things that they think is best and signing it and putting it in their safe. I feel like we should really kind of explain why that doesn't work.
Well, in Florida, there are certain requirements to having a will. For example, you have to be over the age of 18. It has to be witnessed by two people. It has to be notarized. So those are, it has to be in writing. Actually, I'm sorry, it doesn't have to be. Yeah, it must be notarized, must be signed by you and attested by two witnesses. It must be written. So you can't just write something and put it away,
right?
And think that that's going to be, enforceable,
right?
So, if it's not enforceable, then you're going to fall under Florida's intestate statute, and intestate simply means without a will.
Right. I was going to say, so it's almost as if you never had a will to begin with.
Right. Exactly.
And what are your thoughts on things like, and I don't know if they can still do it these days, but I know there's will forms. I think once upon a time, I think they were like an Office Depot where you could just go in and get a form. And then there's, of course, different legal doc websites where they're not actually attorneys that are creating these for you, but they allow you to kind of plug in some information. You can get things witnessed, as opposed to actually hiring a trained and experienced attorney. What are your thoughts on that?
Well, as an attorney, I guess I'm always going to recommend that you hire an attorney. Because mistakes do happen. For example, I had someone come in about a will that wasn't witnessed. There were no witnesses. There was a notary who could, who technically could serve as a witness, but and so it, even though we knew that those were the decedent's wishes, the will, was invalid.
Right.
So you don't want to, go through that whole process of preparing a will and then it ends up not even being valid. So definitely consult an attorney.
I agree, because a lot of those forms may not even be up to date, and the law is kind of a living and breathing thing. And I don't know that there's been many recent changes when it comes to the intestacy laws or different things in probate and estate. But if they do change, that form you might have purchased, may not have accurately reflect what the current law is at the time that you bought it. So
right.
I think
and then sometimes when you have those documents, even though it seems like it's laid out, people don't always even complete them properly.
Oh, for sure.
Yeah,
and they're interpreting it in a layman way without actually understanding what's supposed to go there legally. So I could see that for sure. So I want to go back to something that you mentioned about avoiding probate, because I feel like that's the natural thing for people to want to do, is to avoid the process altogether, especially when you're dealing with the death of a family member and it's just a lot of things going on and no one really wants to have to go down that road if they can. And so I feel like we should touch on whether or not someone can prepare in advance to avoid the probate process, or is it unavoidable?
No, well, it can be avoidable. It depends on your assets and the fact situation. I mean, that's probably the number one request that I have in my office. Everyone wants to know, how do I avoid probate?
Right.
They just hear about probate and they just, think it's just this nightmare thing that they don't want to get involved with.
Right.
We try to make the process as easy as possible for our clients and try to make it as straightforward as possible. But, proper estate planning is the best way to really try to avoid probate. If you speak with the attorney about your individual situation, they'll look at your assets, what you own. For example, if you only own your home, you may be able to just do a ladybird deed, which is also called an enhanced life deed, which would transfer upon death. So any assets that transfer upon death don't have to go through the probate process.
Oh, okay.
As long as the transfer is done correctly.
So then how is a ladybird deed different from a living trust? Because I feel like I don't necessarily understand the difference there.
Well, so a ladybird deed is a deed. It's just like a warranty deed or a quick claim deed or, something like that actually, but what it does is it only deals with that particular property, whereas a trust may have multiple assets in the trust.
Okay, I see.
Right.
So we're talking ladybird, we're talking about real property.
Yeah.
But a trust can encompass a whole lot of different assets.
Absolutely.
Got it. Okay. I understand that. And so then if you have a simpler estate or something that may be, like you said, just your home or something like that, then there may be ways that they can plan ahead to potentially avoid probate, if you will.
Absolutely.
Okay.
Yeah.
Now, obviously, let's just kind of go with a traditional scenario. If, let's say, a family member, a relative passes away, they do have a will, and they come to you for an assistance. Kind of how long is that process expected to take, and what does it really entail?
So
and let's assume we have a valid will.
Right. And you're not contested. There's no litigation or anything like that. So, yeah, typically if someone comes, so a lot of my clients, they just, the person just owned a home, right?
Mm-hmm.
And so we can do what usually do if it was their homestead, we can do a summary administration. We can do it as quick as 45 to 60 days.
Oh, wow. Okay.
Mm-hmm. But if you're talking about formal administration where a personal representative is appointed, you're going to look at least, probably the court's like you to wrap things up within a year.
Mm-hmm.
But, it can go 1 to 3 years. It just depends on the amount of litigation. I have a case now that's been going on for almost 10 years.
Oh, my gosh.
Yeah. So it just depends on the case.
Yeah. And I would imagine, as you said, if the issues are being contested, if, there's people that maybe have competing wills or there's issues in regards to who should get what, then I could see how that could go on for quite some time.
Mm-hmm.
So then when it comes to contested issues, how is that usually addressed? Is it a trial? Is it a mediation? Is it arbitration? How are those kinds of issues dealt with?
Well, we don't have it can certainly be a trial.
Mm-hmm.
It can certainly be a trial. You can mediate. Don't necessarily do arbitration. I've never had a case to be arbitrated in my practice, but for the most part, it's you can mediate. The beneficiaries can mediate, try to come up with an agreement, or certainly you have a hearing in front of the probate judge.
Okay. Mm-hmm. All right. So then, is it almost kind of like a divorce in a sense that the judge kind of hears the evidence and makes decisions or rulings when it comes to the probate, or is it different in that sense? I feel like I may be coming up with a bad analogy.
Well, if it gets to that, but honestly, most cases don't get that far.
Okay.
We don't. Yeah, we very rarely, as in my practice. Maybe if you have someone who strictly does probate litigation or something like that, but in my practice, for the most part, we don't have final hearings very often. Yeah, it's rare.
Okay. Yeah, it's similar with workers' comp law, which is administrative law, and the final hearings are only if we can't resolve the issues, and usually we get them so narrowed down to that the time it does go to a final hearing, it's usually on one little small narrow issue at that point, but they don't happen as often as one might think. Okay, so then when we were talking about value, and then as far as if it's a smaller estate, maybe there's just one home or homestead, and that can be maybe handled by Ladybird deed. Does it matter how much there is in the estate, or does it have to be a certain worth to the estate before you say, okay, this needs to be probated versus there's nothing here, there's really no assets, or this can be done on your own? I feel like it's hard for me to gauge who needs to come in for a probate attorney once you have a significant other or loved one or someone pass away.
Yeah. So it does depend on the fact scenario, but in Florida we have different levels of, probate. So we have disposition without administration. So if you have an asset with a value less than the amount that you paid for the funeral expenses, which you are only allotted up to $1,000 for the funeral expense. $6,000 for the funeral expenses. So if you've spent that and you have an asset, let's say you have a car, an old car that's worth less than $6,000, you need to transfer it. So you might do disposition without administration.
That's exactly what I was thinking. I'm thinking, what if they just have one or two little beat up cars? What do you do with that? In
that scenario. And then the next level would be summary administration. If you have exempt assets that are less than 75,000, or exempt assets. And then the decedent has been deceased for more than 2 years. You might do summary. Then formal administration, if you need to appoint a personal representative, for example, in your field, personal injury, if you have like a wrongful death case, there might be a need to appoint a personal representative. There might not be any assets, but you need the personal representative to begin the wrongful death case.
Exactly.
Yeah. So in that case, you might appoint a personal representative, or if the assets are greater than 75,000.
Okay. And how do people, is there a certain person, because obviously we think of it in a certain way when we're talking about personal injury, but when people are deciding on who their PR is or who they want to be their PR, is there a certain person or entity that you recommend, or does it really matter when it comes down to it?
No, it doesn't. Yeah, mainly people just choose, if they're married, their spouse, their children. We normally name, 1, 2, and 3, successor PR. So if that person isn't available, if they predeceased you or something,
right,
then, you would have another person that you would name. But normally it's just friends or family, mainly family.
Right. Because I was wondering, when you kind of do those, I think it's the letters of administration, when you're asking the judge to appoint, does the judge really care who it is, or does it have to be, or the judge say, no, this is not a person that we recommend or would see fit, or do they always just approve whoever is appointed?
Well, no, because there are, requirements. Like you have to be over, the age of 18. You can't be a convicted felon.
Okay.
You have to be bonded, so the bonding company will even look at credit. They'll do a credit check, and so so there are those stipulations.
Right. Also, that's something to be mindful of then when people are looking into who they should kind of appoint as their PR. Good to know. I don't think I even ever really knew that. Okay, so I think, Tamara, it's a good time for us to take a short little break. We do a commercial break, and after that, we will be back with some more probate, estates, wills, trusts, guardianship conversation with Tamara Felton Howard, and we will take a short break, and we'll be right back.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
This is FLA Law live on the radio. As you know, this is WTAN, and you have been listening to FLA Law live on the air with our special guest, Tamara Felton Howard, who is a probate and estates attorney. And we've been getting some very good legal information in regards to probate. And so before we took the break, we had been kind of going over various scenarios in regards to the probate process, how long it takes, and so forth. So I wanted to ask one more question before we kind of jump into some of these frequently asked questions that I saw on Google about this topic. But we kind of touched on it a little bit, but I don't think we actually answered the question about whether or not there's certain things that are exempt from probate.
So there are certain things that, well, let me say this. So there are things that are exempt from the claims of creditors in probate.
All right.
Such as your homestead property, personal property up to a certain value, up to 2 vehicles, so those are things that can be exempt from the claims of creditors.
Okay.
As far as an exemption from probate in general, there are assets that you may not have to probate. For example, if it's jointly titled with someone else, if someone else is on the bank account or on the home or something like that, joint tenants with rights of survivorship, or if it's a husband and wife, you don't have to, it just automatically goes to the surviving spouse and there's no need to probate.
Got it. Okay.
So in those instances where it transfers upon death, then you don't have to probate.
That makes sense. So then that you actually raised 2 questions that I have. So the first one, talking about creditors. So do any creditors that you had while living still have the same rights after death, or can some creditors go away? So I feel like there's student loans, there's credit cards, there's medical debt, there's, car loans. There's so many different things. And I feel like, does any of them discharge upon death, or do all of them have rights to the estate when someone dies?
So for the most part, creditors would have a right to the estate property, unless, for example, if the only asset in the estate is exempt, then there wouldn't be any assets for the creditor to receive. I know a lot of times with student loans, and I don't want to quote policy. I don't know what policy might be today, but I know a lot of times with student loans, they do get discharged. But
that's good to know.
But as far as other debt, yes, you would, if the assets are there and the creditor files a claim against the estate, then they can be subject to being paid.
Right. And if I remember correctly, is it a 2-year limitation in terms of the creditors that they have to basically make their claim or state their claim on the estate? And if that time passes, then they basically no longer have the ability to claim against the estate?
That is correct. There may be exceptions, because I'm trying to think. I think the IRS may.
Oh, of course. We can't get away from the IRS, can we?
To look at that. But for the most part,
not in life or death.
Right. Yeah.
Okay. Yeah. Well, we definitely keep that as a caveat.
But I think the exception, especially with IRS, a lot of times there's a lien. So if there's a lien against property,
gotcha.
Like there's a mortgage against your home, well, you can't avoid that.
Right.
It's a secured debt. Yeah. So.
Okay. So then the other question that I had when you were answering earlier that came up in my mind is a joint tenancy situation, or, property that you may own with someone else. And so I completely understand if it's a spouse and you own the property with the spouse passes away, that can pass without the need of probate. But what about a situation where you're not married? Let's say you have a property that you own with a friend, and that friend passes away. Is it still the same in terms of, not, I guess, being exempt from probate?
It depends on, it depends on how you have it titled. So if you and the friend, you can have it titled as joint tenants with rights of survivorship, and in that case, whoever the survivor would inherit the property.
I see. Okay, so it all depends on how it's been deeded, if you will.
Right.
Gotcha. Okay, and so then, because I was just thinking out loud, thinking of a situation where if it's owned jointly, but when that person passes, if they have a spouse, let's say your friend is married and they have a spouse and kids, do they have any entitlement to that, or is it,
They do if it's owned as tenants in common. So if you own it as tenants in common, for example, it's 2 people, you each own 50%. And then if the other party passed away, then their heirs or beneficiaries would inherit their portion.
Got it. Okay.
Under Florida law. Yeah, and everything we're talking about is Florida law, by the way.
Right, exactly. And that's fortunately, hopefully, where all our listeners are tuning in from. But I guess they could be streaming from any parts of the world. So yes, we are definitely talking about Florida law here. So with that being said, I want to talk about a scenario that I saw on Google, and I think it's very common, and I know I've seen it in my own personal family and other people's families and my in-laws. I feel like this happens a lot, and so I wanted to kind of see if we could break it down and discuss the issue of a situation where, let's say, there is no will. So we're getting into, I guess, a situation of discussing Florida intestacy laws and how it kind of passes. But before we do that, I think the thing that pops up in my mind, I think we see often, is Grandpa Joe or somebody had a property. And in that property, there was no will and he died. There was never any estate that, was set up. And then Auntie Susie or somebody is living there with her family. They've always lived there. That's just always been the case. And then just decades go by. And at some point, somebody says, well, we need to go through estate and we need to go through probate. And we realize it's still titled to Grandpa so-and-so who died long, long time ago. And what happens in those kinds of situations?
Yeah, that could be one of the worst mistakes.
Yeah.
Waiting decades to probate a property. And there's no will, because what happens is, under Florida's intestacy laws, we have a statute that governs, the transfer of assets without a will. And so it could go to, your descendant, and let's say someone passes away, they're not married, and it goes to their children. And then let's say they had 5 children and 2 of the children have passed away. Well, every time someone passes away, then it passes on to more lineal descendants. And so I have a property with 23 people attached to the property. And so it just becomes a nightmare in trying to get in contact with people. It may be someone's passed away and they didn't probate their estate.
Oh,
so
my goodness.
It's like, how do we determine who, we have to determine who were their proper, or who the, heirs. Did they die before our decedent or after? It can be a nightmare.
Yeah. So, and to me, I visualize it as like this big pie chart. And every time somebody dies, the pie just keeps getting divided over and over and over again. And the slithers get smaller and smaller in terms of who gets what. And I don't think people necessarily realize that, where it could be a situation where, somebody's always been in that home, or they're paying the taxes, or they're maintaining it, and then they expect that they can just give it to their children when they pass, or that they want to leave it in their will, to their heirs. And it's like, wait a minute, it was never actually really yours to begin with.
Exactly.
So I could see how that could be extremely complicated. So let's, I guess, back up then and explain how does the lineage work when it comes to a situation where we're talking about no will and we're trying to figure out how this asset is going to, be dispersed, if you will?
So it can get, so there's a Florida statute 732.101 through 732.111 that describes the intestate, so for example, if you pass away with a surviving spouse, let's say it's just your spouse, and your spouse would get, and you have no other children, your spouse has no other children, your spouse would receive, 100%. If you, have children, and, the statute looks at, are the children your spouse's children as well? If they are your spouse's children, does your spouse have other children? Like, it's a lot of things.
My goodness.
And so it goes to, your surviving spouse, your children, your lineal descendants. If you don't have any of those people, then you start going up. Like, are the parents still living?
Right.
The siblings, aunts and uncles.
Okay. So then what if ever, is there a situation where the state might be maybe taking control of a property or an asset in the state? And when I say state, I mean I guess the state of Florida.
Oh, the state of Florida.
Mm-hmm.
So the state can take control of property. So if a person dies and you leave an estate and you aren't survived by anyone who's entitled to it, then the state can do what's called, they can escheat the assets. They can take the assets and give it to the state of Florida.
Wow.
And then heirs have 10 years after it is escheats to the state to file a claim. So that rarely happens. Like, I've never had that happen personally in any of my cases, but because usually there's
someone down the line that you can find, whether even if it be remote relative, but you can find someone, right?
Exactly.
That's interesting. So if in the event that there could be no one found and it does escheat to the state, as you said, after 10 years, what happens? Is the state then auction off the property, or what?
Well, the state actually gets the property after, when it escheats to the estate, it goes to the estate. The funds go into, I think, something with like the schools or some sort of fund. But then you have 10 years to file a claim, and so I suppose you would get, the state would then have to pay the heirs once they are located, or if they pop up.
Right. Okay. Yeah. So, and I remember seeing a question then on Google, for example, like if obviously parents can, remarry, and maybe they're married to a spouse who is not the parent or the biological parent of their children. And then I could obviously see how there could be issues when there's no will as to, who stands in first. And it sounds like it's the spouse above the children. Am I understanding that right in the intestacy laws?
Well, so I'm sorry. So the children, explain the situation. Is it the children of the person that's passed away?
Right. So if a child, I guess I'm trying to figure out what the child's rights or where they would stand in line if a parent dies without a will, but assuming that parent is now married to someone other than, I guess, their parent.
So the surviving spouse would not, in that scenario, under Florida law, receive the entire estate. Yeah, it would be divided up between the surviving spouse and the surviving children, because the children are not the children of the surviving spouse.
Got it. Okay. Mm-hmm. All right. So it's almost some form of an equitable distribution then.
Yes.
Got it. Okay. And then I'm really getting into the weeds. So then who decides that, as far as, is it clear in the statute as far as the percentages or how much of what, or is that something that the parties have to agree on?
Well, no, it's very clear as far as who inherits. Okay. And now the amount would just depend on the, like if it's a spouse, spouse gets 50 and the children split the other 50%.
Got it.
How the statute reads.
Got it. Okay. That makes perfect sense then. So that's why it's important, I think, for people to hire attorneys, because trying to interpret, statutes and figure out who gets what and how much, I think would be very difficult to try to do that on your own.
Right. Absolutely.
So I wanted to kind of pivot then and talk a little bit about some of the, things and estate plannings that you can do before death. Obviously, we spent a lot of time talking about what happens after death and how to interpret the wills and that type of process. But I think it's even more important to talk about what can be done, while living, to start planning and ensure that some of the issues that we're talking about don't necessarily become a problem or contested, after death. So I wanted to talk about, what kind of estate planning can be done other than just creating a will, which we've talked about quite a bit.
Right. Yeah, certainly. Creating a will if your 18 years are over and you're competent to sign. You could also execute a revocable or an irrevocable trust.
Okay.
We talked about the ladybird deed, but there are other types of deed, like a life estate deed, or you could just add someone to your deed. I don't always recommend that because you don't get the benefits of inheritance laws, but then, let's see, we made you documents for healthcare surrogate forms, durable power of attorneys, planning for final arrangements, pre-need planning, a living will, which deals with like life-sustaining measures and whether you want to be kept on life support or under what conditions would you want that to happen. So those are some of the, documents that can be executed in estate planning. just depending on your personal needs.
Right. And so how extensive is it when it comes to the process of, meeting with you and trying to figure out how to set up a trust? And you mentioned it was irrevocable or revocable. What does that entail? Do you have to have, your financial documents in order, or, having your whole property appraiser list of everything you own, or what goes into that process?
Well, I definitely recommend coming prepared with knowing, like, what your assets are and who you'd like to leave your assets to, because if you don't know that, then we end up having to have another visit, to talk more about that, about what you actually want.
Right.
But that's fine. I mean, some people just want to kind of know what their options are, and then they want to think about it. But, you certainly can come prepared with, what your assets are and who you want to leave them to. And then we can talk. Some people think they need a trust, and they really don't.
Right.
But, anything you do, I think in estate planning is going to be probably cheaper than what you pay on the back end, or what someone is going to pay. I mean, if you're deceased, you're not necessarily paying, but that someone's going to pay on the back end. So,
well, you bring up a good point then. So then what about the situation, and maybe more beneficial to, wait in that situation, but in a situation where, let's say, mom and dad, they are doing well and they have a good amount of assets, but they leave behind a child who is poor and doesn't have any money. And they're like, wait a minute, how am I going to retain you? I don't have any money. Do they pay up front, or is the attorney paid through the assets of the estate and the distribution? Or how does that work when maybe you have a substantial estate, but the person that's left behind has nothing?
Yeah. I think it probably depends on the attorney. Some attorneys are open to, payment from the estate, and then a lot of times that is how it's done.
Okay. Almost like a contingency fee, like personal injury.
Right.
Okay.
Right. Well, not contingency, but it would be, the state statute lays out, what attorney's fees can be paid from an estate. But for the most part, an attorney may take a retainer up front.
Right.
They may take a flat fee. They may say, we'll pay costs, and then we can pay the balance later, out of the assets of the estate. So it could be different scenarios.
Right. And then on the flip side, then if you're trying to take care of it in advance and you're doing the estate planning, you're setting up your will or trust and things like that, then how is that typically? Is it more like a flat fee or hourly, or could it go either way?
It could go either way, depending on how complex the estate planning is. I tend to charge a flat fee because I kind of already know, based on our conversation, how long it's going to take.
Sure.
But if you, depending on who you go to, if it's a complex trust, it may be an hourly fee rate.
Right.
Yeah.
And so then, in the grand scheme of things, I think the issue that I think people have is it something that I can do on my own? Do I really need an estate attorney to help with this process, or can I just go down to the clerk and file the will and get things set up and just handle it myself? And of course, I know the default response, but I feel like we need to share with our listeners.
Right. I mean, the default response is, no, get an attorney.
Absolutely. Not just any attorney. We could have called Tara.
Right, absolutely. But no, I've had people, a summary administration that may take my office, 60 days to complete. 2 years later, they're still working on it, and they finally come and like, look, I'm sick of getting these checklists from the court.
Yes, I've seen it. Like, I feel like it's like always something, and you're like, the way I thought I did that right, and that wasn't right, and then the judge kicks it back. And so I've had a little bit of experience with seeing it. So but yes, sorry, I didn't mean to cut you off. So then people do often attempt to do it on their own then, right?
Sometimes they do. But I probably had one client who came in and she had done a really good job. I had to compliment her. She actually did a good job. I think she had a little help, but yeah.
So then I think, I feel like because there's so many nuances in the law and different things as procedure and deadlines, it's just, more beneficial to go through it with an attorney. Unless, like you said, there's maybe a situation where there's less assets, and then maybe certain things that are exempt. So things like, just personal effects, clothing, jewelry, things of that nature. Do those kinds of things really require probate, or can people just walk in their significant other's house or their relative's house and just take those things out?
No, I mean, that's not what you're supposed to do. Now, in all practical purposes, that's very often what happens.
Exactly.
But I mean, especially if the person has a will, they may have designated, this necklace goes
certain
to
items,
my granddaughter. Or even if they didn't do that, whoever is the beneficiary, like if it's 3 children, all 3 children have an equal right to all of the assets. So it's not really fair for you to go in and you clean the house out and then the other 2 don't get the benefit of getting anything. So, in practicality, a lot of times that does happen.
And is there any recourse? And people come to you and they say, Tamara, my mom had X, Y, and Z. She had all kinds of things and different items that are now gone, and her house is empty. And I think cousin so-and-so or my brother or whatever did that. Do they have any recourse to retain you and to assist with any of that?
There is recourse, but the problem very often that I find is that we have to prove that those items
were actually
existed.
There. Yeah.
Right.
Yeah.
So
that
I mean,
sense.
And even if they owned them the day before they died, they might have gotten rid of them, the morning before that they passed away. Like,
Sure.
You don't know whether they actually still
existed.
Yeah. So that can be complicated.
That's a good point. So then could you almost look at it like, if a hurricane's getting ready to come, for example, they, homeowners insurance policies, they recommend you go out and you video your property and record everything and take a look at what it was before you left town and evacuated. Could you see something similar like that if you have a ailing loved one, maybe they're in a nursing home or they're in hospice care, that you should document things that might be there?
That's absolutely not a bad idea. Yeah. I mean, you certainly could do that. And then at least you have more proof than nothing, than not having anything. Yeah. Right. And then you have to, beyond the fact that it existed, then you're trying to prove value.
True. What it was actually worth at the time. Yeah.
Right.
Okay. Well, Tamara, I thank you. Thank you so much for joining us and being our special guest this evening. Before I let you go, I would love for you to let all of our listeners know where you're located, how they can find you, the best number to reach you, so that if they have any follow-up questions or would like to retain you, how would they go about doing that?
Absolutely. And thank you so much for this opportunity to be here. I really enjoyed it. But I'm Tamara Felton Howard of Felton Howard Law. We're located at 5203 Central Avenue in St. Petersburg, Florida. And I can be reached at 727-202-8626.
Awesome. And so you've heard it here live. If you need help and assistance with the probate estates, wills, trusts, guardianships, all of the above, then Tamara obviously is the person that you should reach out to. And of course, as you know, for all personal injury related matters and future questions about that, we are here every Tuesday at 5 p.m. on your drive home. And when you're getting off work, you can tune in to FLA Law on the radio. Thank you once again, Tamara. I enjoyed having you and hope that maybe we can have you again in the future.
You're welcome.
That is our show, folks. And we will see you again next Tuesday at 5 o'clock.